Nobody in the queue? All right. Sarah McClellan. We have
this is the bill that requires new sentencing hearings for those not.
Give us one second.
Okay.
This bill, I would point out to the members of the committee, is identical to a bill that was introduced by Senator Wexton last year.
Yes.
Senate Bill 825. So this is not a new bill to the members of the committee, and it reported out of this committee on a 9-6 vote. So with that introduction, Senator, go right ahead.
Yeah, you took half of my presentation. I was just going to remind everyone, this is the bill that would require or allow those individuals who were convicted of nonviolent felonies between the time parole was abolished and between the time that the court decision in Fishback versus the Commonwealth came out. Again, you've seen this before, voted on it before, and unless you have any questions, I think it's self-explanatory.
Let me ask you, do you have any idea how many of these people are still in custody at this point in time?
I do have that. It's not very many.
Mr. Chair, I think it's in the fiscal report it says 10.
Yes.
All right. Thank you. So, and one question that I have, given that the universe of inmates is 10, I mean, is there a reason we need to do this as opposed to relying on the clemency or pardon power of the governor?
Well, I think it's sort of more a matter of just the public policy that there were those individuals who were sentenced under the old rule, who were sentenced and juries didn't know that parole had been abolished, and just sort of the public policy statement that you know, they probably were not sentenced with full information.
And I know this is a question that I had last year, but given that this was 17 years ago that this decision was issued back in June of 2000, how do you ensure that the victims get a fair shake at the resentencing? I mean, is that even possible?
Well, I think for those that want to come and participate in the resentencing hearing, they would be afforded that opportunity to do so. I imagine that the transcripts from the prior sentencing hearings would probably be available, so to the extent they're not available, they're not here today, but they would have been at that prior hearing. Hopefully that would be public record.
But being a trial lawyer myself, or a litigator, I guess trial lawyer, I shouldn't say that, but being a litigator myself, the difference between a transcript and the live testimony of a victim almost contemporaneously, I mean, that's a big difference, isn't it?
It is. I guess there's just sort of the fundamental unfairness of the fact that there were people who were sentenced and juries believed one thing, but something else was true, that just giving an opportunity for juries to have full information.
Senator Norman.
I don't know much about criminal law. When did a victim impact statements, when was that inserted in the code?
I don't know that.
I would suggest to you that it was subsequent to the 2000, and a concern, Mr. Chairman, I would have, if because of the passage of time, if we were unable to locate and engage the victims, how they would have an opportunity under the impaneling of a new jury to have a victim impact statement.
Mr. Chairman, one thing to bear in mind is that the patron's bill only speaks to felonies that are nonviolent felonies. And so we would not be denying the victims of crimes of violence an opportunity to be heard.
Okay. Any other questions, patron? Anybody wish to be heard in support of this bill? Anybody wish to be heard in opposition to the bill? Yes, ma'am.
Good afternoon. I'm Theo Stamos. I'm the Commonwealth Attorney for Arlington County and the City of Falls Church. I'm here today on behalf of the Virginia Association of Commonwealth Attorneys, and we do oppose this bill for some of the reasons that Senator Obenshain commented on. And also, if there were to be a resentencing, there's no provision for information to be presented to the jury about the inmates' incarceration period, whether there have been new offenses that have been committed or disciplinary issues. So I think for those reasons and what Counsel Senator Obenshain has said, we oppose.
Mr. Chair,
Senator Peterson.
could I ask Theo a question?
Certainly.
If there's only 10 inmates, and as if our counsel said they're nonviolent felonies, you're probably talking about either drug distribution or maybe a financial crime. I mean, would it be that hard to kind of bring the information back in front of a fact finder in this case?
I mean, hard, probably. It depends on how long, it's been. But I think that the concern that we have is the sense of finality. I mean, this and the notion that the idea of no parole was even considered or not considered by a jury is speculative. So, I mean, the limited number, I think probably the avenue might be a pardon for that small number. But I also think that if this were to pass, then I think that the jury that's reassembled ought to know and be able to consider a higher penalty if during the period of incarceration that inmate had accrued new offenses, convictions while incarcerated. That happens. The disciplinary record of that inmate should be made known to the jury that sentences. So I think you need to have a transparency issue with that.
All right, thank you.
All right, any other questions?
Mr.
You wanna wrap it up?
Yeah, since the snow prevented any folks from coming out today, this is supported by the Virginia NAACP. It's part of their legislative agenda, the resource information help for the disadvantaged and disenfranchised organization, and this is part of the legislative Black Caucus agenda, but snow kept folks away.
All right.
Mr. Chairman, to further answer an earlier question from Senator Norman, we looked up the section for victim impact statement, and the earliest passage date we find is 1983, with various amendments in 1984, 87, 89, 93, 95, and then 96. So it appears to have been in some form always in existence. Another question was whether clemency could serve the same purpose, and I would think not. Because that would put the governor into the unusual position of essentially performing a sentencing function, which is a constitutional trial right for an accused in Virginia. And so I wanted to make sure I made those 2 points.
Sir Norman.
If I could ask Mr. Benjamin, how about a limited pardon?
Well, one form of pardon, of course, Mr. Chairman, is a commutation of sentence. And we do see that on occasion where there has been what appears to be, I think to everyone, a miscarriage of justice, a disproportionate sentence. I don't know that these are good cases for that. And I'll tell you, I think every single one of those 10 have contacted our office for representation. And so I know that they're concerned and feel very strongly about it. We don't do that work, so I have no conflict of interest here.
All right. Anybody else have any questions with that? The bill's before us. Is there a motion? It's been moved and seconded. The bill be reported. The clerk will open the roll. Who else do I? Oh, yeah. All right. Clerk will close the roll.
Ayes 8, nays 7.
All right. Your
Thank-
bill reports.
Thank you.
And 734.
Yes. 734 is a bill that would provide for the audiovisual recording of custodial interrogations where practicable, but makes clear that failure to make such a recording will not affect the admissibility of any statements made during